Okay, so we'll call to order the Board of Commissioners Land Use meeting today, May 14th, 2025. It's 1:30, and it is regarding file number 439-24-00008 LRP. And the purpose of this public hearing is to consider a Jackson County Planning Commission recommendation of approval for a minor comprehensive plan map and zoning map amendment to change the comprehensive plan map from commercial land and White City urban residential land to industrial land and rezone a parcel containing 2.09 acres from general commercial to light industrial, and a parcel containing 0.75 acres from White City Urban Residential 4 to light industrial on properties described as Township 36 South, Range 1 West, Section 20C, Tax Lot 400, and Township 36 South, Range 1 West, Section 20CD. The tax lot is 1,300 and located at 2291 and 2297 Gramercy Drive, White City. The application was submitted by CSA Planning LTD and agent for PAC Holdings LLC, and its file number again is 439-24-00008 LRP. So with us today, we have Ted Zook, Director of Development Services. Kristen Mays is here with us, a Planning Manager. Don Cox, a Planner 3. And Joel Benton, Senior Assistant. No, you're Senior. You're the County Council.
I am.
All right. Got that set. So can we have our admonishment and the rules for the public hearing today?
Sure, I'll start off with the admonishment. Please remember to direct testimony and evidence toward the criteria or rules set forth in the published notice for this hearing. Those criteria, rules, and standards will be further outlined by staff momentarily. Testimony may also be directed to other criteria in the comprehensive plan, land development ordinance, or other land use regulations that you believe apply to this decision. Understand that a failure to raise an issue with statement or evidence sufficient to give the decision makers or other parties the ability to respond to the issue will preclude or prevent your appeal based on the issue. We are making a verbatim recording of the hearing. In the event of an appeal, it may be necessary to transcribe the recording. Therefore, when you testify or comment, please begin by identifying yourself so that anyone reading a transcript of the record will know who is speaking. We'll first hear from staff, and the applicant will follow. Then we'll hear from those who wish to comment in favor of the application. Then we'll hear from all those who are opposed. The applicant has the burden to prove its case, thus the applicant will have an opportunity to respond to the comments and opposition at the end. Once everyone has had an opportunity to speak, the public hearing and the record will be closed unless there's a request for continuance. If there is such a request, then another set of rules will apply. However, if there is no continuance, then the commissioners will proceed to deliberate toward a final land use decision. There's a couple of housekeeping issues to resolve. First is the opportunity for the commission to announce whether they have any ex parte contacts. If there has been an ex parte contact, the commissioners will discuss the nature and context of the ex parte contact so the parties are aware of the substance of the communication when the hearing is open today, and will have an opportunity to rebut any evidence obtained by ex parte contact. Commissioners, have you had any ex parte contacts?
No. I've had none.
I have none.
And then second, this is the opportunity for the commissioners to announce whether they have any actual or potential conflicts of interest with respect to the matter today or the applicant. If so, the commissioners can discuss the nature of the actual or potential conflict and address how they wish to proceed. Commissioners?
No conflict.
None.
And I have none.
Thank you, Madam Chair. I will move on to the reading of the rules for today's public hearing, which, pursuant to our codified ordinance, only the chairperson or a member of the Board of County Commissioners may question the speaker. There will be no interruption of a speaker from the audience and no debates on the floor. Applause is not permitted. A speaker may criticize the proposal, the board, or an agency of the county, but the speaker shall not argue with another speaker directly. Any speaker may present the opposite view, but not in personal terms. The person wishing to speak shall sign in, raise his or her Zoom hand, and otherwise be recognized by the chairperson conducting the hearing. After being recognized, the speaker shall state his or her name and address before proceeding with his or her statement. The chairperson may delimit the duration of any presentation to time necessary to cover factual information. Repetition shall be avoided. Whoever violates any such rule shall first be warned by the chairperson to desist from such violation. In the event that such person does not so desist, he or she may be ordered by the chairperson to leave the hearing. Thank you, Madam Chair.
Thank you. And so we'll move on to our planning staff report. And I assume that's Dawn.
Good afternoon, Commissioners. I'm Dawn Cox, Planner 3, Jackson County, 10 South Oakdale, 97501. The application before you requires an amendment of the Jackson County Comprehensive Plan map and a zone change. Approval of the proposal will add 2.84 acres to the light industrial zone. The subject property is shown in yellow, located on Gramercy Drive near the intersection of Highway 62. The subject property is bordered on the east and northeast by White City Urban Residential 4, on the southeast by Rural Residential 2.5, on the southwest, west, and northwest by General Commercial. The subject property has been in use related to metal scrap intake storage since approximately 1985. The existing industrial use will become conforming to the zone as a result of the proposed comprehensive plan map and zone change. The agent's findings address the applicable criteria in pages 50 through 74 of the Planning Commission record. The evidence submitted by the applicant supports a minor comprehensive plan map amendment and zone change. For this reason, the Planning Commission recommends approval. Are there any questions of planning staff?
Any questions? Nope.
Okay,
Thank you. Okay, so we will hear, does the public hearing, we open it up first? Okay, so we'll open the public hearing and we'll hear from Raul Warner from CSA Planning first.
Good afternoon, Commissioners. I'm Raul Warner with CSA Planning Limited. We represent the applicant Pacific Holdings, LLC. My office is at 4497 Brown Ridge Terrace here in Medford. The Pacific Holdings is the property owner entity. They also have the business Pacific Recycling, which operates the business on the site. This area had been part of the White City Metals complex that had included other properties, including the adjoining properties to the west and some south of Gramercy Road. Over the years, some of those parcels were spun out and the operation was split up. So it was a full services metal business before, where they brought in the metal, they'd repurpose it, and they'd sell it retail on the site. And the parcels to the west are now the retail operation, where it's a different business owner that has that, but they have metal for sale, the retail side of it. And our side of it is the intake. It's the old, where the feedstock came in. And Pacific Recycling takes it and they ship most of it up to their plant in Eugene. It just needs to be separated out here and loaded up and taken to the proper recycling areas. So that's kind of the nature of the operation. But the properties are zoned commercial on the western side at 2 acres, and the easterly 3/4 acres is zoned residential. However, it hadn't been before the White City Urban Unincorporated Community Plan was adopted. I think there was a mapping error. It had always been commercial before that. I pointed out that it appears there might have been a snapping error on the larger community plans on this one little lot. So really, it's always been a couple of commercial lots. The light industrial is a better fit for the uses on the site. Recycling is an important part of the community. Having places to bring things to and not throw it in the landfill is very important. Besides the fact that the property's already been in use in an industrial capacity for many years, we also had an economic analysis done just showing a generalized need for additional light industrial parcels in Jackson County, and that's in evidence in the record prepared by Johnson Economics. So we've established a need for industrial generally, and then established that the site is an appropriate place to select because it's kind of been committed to the use since this particular lot since '85. But The surrounding lots, White City Metal started back in the late 60s, so it's been a long-term operation and presence in the area. We had some neighbors testify at the Planning Commission hearing, and they're concerned about the operation, but our client is working on getting a site development plan prepared so we can bring it more into compliance with the current development standards. And that is to add like some pavement, hard surfacing to keep the dust down, put in a well, and all the other things that you would normally do when you first start up. Of course, this is a business we're retrofitting to meet current standards. But in order to do that, we really need the zoning in place so that they can feel secure in putting the investment of time and money into pretty complicated designs and engineering plans and actual capital. And if it's characterized as a non-conforming use, lenders really don't like that when they're trying to get that finance. So it's important to get the zoning in place. You can stand for questions if you have any.
Any questions? No, we don't at this point. Thank you.
I'll reserve time for rebuttal.
Okay. Next up on our sign-up sheet is Terry Johnson. If you want to testify, give your name and address for the record, please.
Yeah, Terry Johnson. Address is 2337 Gramercy Drive, White City, Oregon. And I was here at the last meeting, and my biggest concern, as I said to you, is the part of dust control. It's a health hazard. I've had lung problems for the past couple of years. But the more and more on improvement, when do they have to comply, even pertaining to today, to keep the dust down? So they attend, what's the guy's name? Sam Arnold called me last week. He goes, I figured I'd check in with you. I said, okay. And he says, everything getting better over there? I said, it's still dusty. He goes, oh, no, we're watering it several times a day. I guess they've got a portable water tank they got on a truck or something. And he goes, in fact, we're going to have a water truck come in and water it down, which they did, which was great, before the start of the day, soaked everything down. But that can't be every once in a while when it's handy for somebody, because the residents around there, we're done with the dust. You know, is there silica dust? Who knows what comes in on that scrap metal stuff? And it ends up at times being a dust boil, and we're done living with that if there's anything we can do. I've contacted DEQ a little over 2 years ago, left the info here last meeting, and to the county also, and they were saying DEQ and code enforcement was even going to get involved even 2 years ago. Okay, we're going to take care of this. We've notified the company. That's what they said to me, not evidence. And they said, enforcement will make sure they comply because we don't want any dust coming off that property. None of that has changed. They've been squirting with a little water on occasions. Summer isn't here yet. But I don't want to go through another summer where you can't leave your car windows down. You can't, heaven forbid, leave your front door open because the dust is that bad. And that's the only reason I'm here, is we don't have to live in that dust. You got White City Industrial Park on the other side of Highway 62, Antelope Road, Avenue G. That's industrial over there. And the one that really complies to the dust part there is biomass, because I'm sure they have to be through OSHA, all the different standards for the dust control and the sawdust control. But I'd like to see it where it's mandatory that that's in place, where the residents don't have to suffer with the dust we suffered with, especially since this new outfit come in there, I think a little over 2 years ago. You know, show us some attempt. And, you know, watering it once a week type of thing doesn't do anything to control the dust. There's nonstop, you know, regular passenger vehicles and all there all day long. But there's big trucks and trailers, and big in dump all day long. Well, a squirt of water on it's not going to keep the dust issue down. So that's my issue. We're tired of having to live as homeowners in a dust bowl, where it's a commercial, I guess, or whatever, or industrial site. So that's all I got to say.
I have a quick question.
Yeah.
So this has been there for decades. Was it bad before, or have you been there long? You said 2 years since
I've been
new
there,
owners.
6 years? But originally it was White City Metals.
Right.
Then Rogue Metals, they were also linked in Klamath Falls with another business over there, the metal business. But then everything went downhill, but on occasion, he would come in and water Rogue Metals. But when they took over, there was not a drop of water put on that property. It slowly got worse to the point the last couple of years since they've been in business there, I've contacted DEQ, and she was even linked in with the Alameda Fire gal here at the county. I know they're two different things. But she says, we're going to get this under control. We have sent notices to them. They've received them. They're going to eliminate the dust coming off. And code enforcement through county, since they're in Eugene, the DEQ place, they'll make sure they're complying. You got to take care of the dust. And that's been 2 years ago. And we still live in a dust bowl. And I just hope it cures the problem.
Okay.
All right, thank you.
Thank you. We got Jeff, is it Winter? Is signed up if you want to speak.
All right,
Give
my
your-
name is Jeff Winter. I live at 2288 Gramercy Drive in White City. And my place is directly from across the street from the entrance into Pacific Recycling. And when they first took over, I was told by multiple people that they were going to asphalt. And that was 2 years ago. And when I asked about dust control, they told me that, no, we're not going to do any dust control there. That came from Eugene, corporate. And as of lately, I have written down on 430, they had a 300 gallon wire cage tank that they outfitted with a pump and uprights for spray nozzles. And they'd put 350 gallons down, or 300 gallons down. And that was it. One time a day. And then the same thing on 5-1. It was that way. They didn't water until 9 o'clock in the morning. And traffic starts going in there at probably 7:45 every morning. They don't open until 8 o'clock. Or, well, that's what their sign says. But there's traffic in and out of there well past opening and closing. And then on 5-2, they didn't water until 8:20. And on 5-5, there was no water and extremely heavy traffic all day and put up with dust. These are 80-degree days. And we were in dust all day. And when they do water, all the fines from the gravel come out onto Gramercy Drive, and most of the trucks are exiting towards Highway 62 now. There's still a couple that still go out through residential. But they're tracking mud, and even private vehicles coming in and out are tracking mud and fines out onto the road. And then as people drive by on the road, we're in a dust cloud. Something needs to be done. Like Terry said, we're tired of it. It's hard for me to go sit on my front deck because of the dust. And I understand the situation. I'm a retired Navy Seabee. I worked in construction, I logged, and I was a truck driver, local dump truck. And every job that I ever went to, there was dust control, but I haven't seen it. Thank you.
Okay, thank you. Do you have a question?
I wanted to actually a question for council. This an approval of this application is in no way will inhibit their ability to seek remedies or redress grievances on some of the issues that they've had with their dust. This is the ongoing operation through a non-condition.
Correct. So this particular application is going to, so they already are an allowed use on the property as a non-conforming use within the zone. This application will basically has no effect on their operational status as it does today. It just converts or rezones the property to a zone in which this specific use is already allowed. So it's not going to impact the ability of these neighbors to pursue complaints against the property for any environmental or other concerns that have arisen. It won't sort of allow it. The zone change doesn't impact any environmental quality requirements that they have to meet. And I can let Ted sort of discuss the county's code enforcement, because I think I've heard both of these gentlemen say that DEQ said that this was a county code enforcement issue, so I think I can let Ted.
Yeah, Joel's right on that. This is just a zone change, and the application has not come in yet for any of the work that might be done, like the paving or any improvements that they have. So ongoing, there are no conditions as it's a non-conforming use. If they put the application in, we can put conditions on the application, and I'm expecting that the consultant is taking some of this in and will address that within the application, but that's not what today is about. It's just a zone change. As far as the code enforcement, DEQ is the agency that takes care of emissions or dust. That said, it could still be something that's within the conditions and then become a conditions violation, although generally the county is not the one that is enforcing the dust. The track out that I heard, the mud, that is something that is within the county ordinance, and we can address that whether it's a condition or not.
And the applicant's already stated that if this is no longer a non-conforming use and it's in the zone properly, they have some more flexibility with financing or whatever to be able to make improvements and bring it up to standards, which should, in some form, address the issue.
Yeah, I think it's, so we're kind of, the non-conforming use is kind of a unique thing in Oregon. And the issue is that if someone was conducting a use on a property prior to zoning or under the county ordinance for long enough time, they sort of get, I hate this word, but grandfathered in. But they get grandfathered in at doing exactly basically what they've been doing. And so they're not allowed to make any improvements, like including things like put down asphalt or build a building or any of the other things that could potentially address the neighbor's concerns. The only way to do that is to figure out a way to make it a conforming use, which they're trying to do through this zone change. I have heard from staff that this is part of a two-step process. They have to get the zone change so they can make improvements to the property, and then they intend to, but I think Raul will be able to answer that. I don't want to take his thunder as to what that would then be the way to do it. But from a legal standpoint, they really are kind of prohibited from making any kind of improvements beyond what they've been established as their non-conforming use.
Yeah. So an approval here would essentially give the the complaints, the opportunity, or the applicant, the opportunity to address the complaints more efficiently, more effectively, I guess, essentially is what you're saying. And-
Well, it's actually two ways there. It gives them an opportunity to address the issue, but it also gives the county the ability to add some conditions to it. And Joel's correct. Obviously, he's county council, but it is.
I've been wrong before, so.
Anything that is considered new development would not be allowed. Your non-conforming uses.
Right.
You got what you got, and you ain't getting any more. So if they want to do any improvements, it would have to be within the right zone.
Okay, I appreciate it. Thank you.
Sure.
More of a question/commentary. So this would explain why they haven't paved in 2 years. They have to have a conforming use zoning before they can actually make improvements, correct?
I think that's probably a question best asked of the applicant.
Gotcha.
Well, so I have a question then on the ability to even do business as a non-conforming use. Were there no conditions to address that, to even begin?
Well, because yes, that is basically the situation is they developed doing a use. And so all the county can do when it's sort of under Oregon law is is establish what they've been doing, that level of what they've been doing. We can't really been like, oh, you've been doing X, we're going to approve X plus minus Y. Really, the non-conforming use process only establishes what they've been doing, that they're permitted to keep doing that, whatever it's been doing, absent it breaking some other law. And as Ted has said, dust control and those type of environmental things don't fall within the county's purview. Those are state regulations through DEQ.
So even in the future, if they applied, that's a state regulation, it wouldn't be part of the conditions?
Well, we could. That's something that we could do is if they came in, assuming in the future, not to speak for the applicant, I don't know what they're going to do, assuming they came in to try to expand their use, that's when the county would have the ability through approving of the new use to then apply conditions to mitigate the impacts of that use.
Okay. All right. So we will we're still in the public hearing. Is there anybody else that would like to speak or anybody online that would like to provide comments?
Madam Chair, there is no one online.
Okay, so we'll give rebuttal time then to the applicant.
Thank you, Madam Chair. I'm Raul Warner again on behalf of the applicant. It's exactly right. To put the amount of improvements in, either you do a non-conforming use alteration application every time you want to do any change at all, which requires consideration of adverse impacts to the surrounding area and whether you're providing some improvements. But then if you want to make a change later on, it's the same deal. So people can always come back, take another bite at the apple at trying to, not let the business operate as normal. If it's under the right zone, then we can put the right amount of effort and investment in it. And one thing about the Oregon land use planning system is it doesn't go as quick as maybe we all want it to. So to prepare a comprehensive plan amendment and zone change requires, either traffic study or waiver of the same. You affect more than 2 acres of employment land. State law requires us to prepare an economic opportunities analysis to justify why there's additional need. There's just a lot of studies that have to be done just for that. So hence the delay. If we could do some policy changes where the state and county could just order improvements to be made without requiring the application to put it in, that might be sort of a police remedy for that type of thing. But they want to put in pavement and put hard surfaces in, and that's going to be the key to controlling the dust. The dust isn't really so much from the metal; it's from the dust on the ground. I've got them engaged to engage an environmental consultant to figure out the dust management plan, and that will be part of the site development plan. Land use application requires that the compatibility with the surrounding area be addressed, and applications will include stipulations or proposals to deal with that, and then the county can adopt those as conditions of approval or augment them with additional conditions if they see fit. So that's where we're trying to get to.
Any questions? Okay.
Well, thank you. And on the state rule stuff. You know, the county still has the neighborhood compatibility nexus for conditions of approval, but the state, we still have to go through DEQ for not only the air containment, but also water quality. And so when we put in pavement, there always has to be a stormwater management plan put together, and the state has to go through that, and there's an environmental process for that as well.
Alrighty. So we will then close the public hearing and deliberate. And I guess, first of all, we'd find out how many exhibits are going to be entered into the record.
There are 11.
Move approval of Exhibits 1 through 11 to the record?
Second.
Commissioner Dyer?
Yes.
Commissioner Sparacino?
Yes.
Commissioner Roberts?
Yes. And so now with whatever motion we will make, we will deliberate.
Well, I will go ahead then and make the motion based on the evidence and testimony. I move to approve the application for a minor comprehensive plan map and zoning map amendment to change the comprehensive plan map from commercial land and White City urban residential land to industrial land, and rezone a parcel containing 2.09 acres from general commercial to light industrial, and a parcel containing 0.75 acres from White City urban residential 4 to light industrial on properties described as Township 36 South, Range 1 West, Section 20C, Tax Lot 400, and Township 36 South, Range 1, wait a minute, I'm sorry, Range 1 West, Section 20CD, Tax Lot 1300, located at 2291 and 2297 Gramercy Drive, White City. Application was submitted by CSA Planning Limited, Agent for PAC Holdings, LLC, file number 439-24-00008-LRP.
Second.
And
open for discussion then.
Yeah. I think after the discussion and after the clarification, I think it's obviously appropriate and meets the criteria, but also has the potential to improve things for the neighbors and allow the applicant to make those necessary improvements that they and seemingly intend to do.
Agreed.
I agree. It's sad that they have not been good neighbors for 2 years, and that leaving them the way they are, I don't think will improve it. Possibly this is a pathway to put conditions that the needs of the neighbors are met, and conditions of dust and livability are better. So it's the only thing that gives me hope in that as well. So we'll take a vote.
Commissioner Dyer?
Yes.
Commissioner Sparacino?
Yes.
Commissioner Roberts?
Yes. So the application has been approved. We'll ask staff to prepare an ordinance of approval and set the dates for the first reading for June 4th, 2025 at 9:30 here in the courthouse auditorium, and the second reading June 18th, 2025 at 1:30 p.m. and here in the courthouse auditorium. And both are on Zoom as well, I assume. Okay. With that, we will adjourn the meeting.